So, as I told you, the recurring theme of this conference is to look at various levels of legal arbitrage as far as that arbitrage is corporate finance related. And so far, we've left out one very salient level of that arbitrage, and that is actual contractual arbitrage. That is choice of law clauses in contracts. We've been alluding to that in Narene's talk and also at Sebastian's contribution. But Timo is going to face this head on now with regard to bond arbitrage. There you go, Timo.
Thank you. Thank you for the invitation, and dear all, it's a pleasure to be invited to speak on the choice of law and bond terms as a tool for legal arbitrage. The issuance of debt securities has traditionally been a key pillar in the financing of German capital market-oriented companies. In 2024, the volume of outstanding corporate bonds issued by German entities reached a historic peak of 473 billion euros. Two developments have likely contributed significantly to this. The recovery of the German SME bond market, which had experienced the highest levels of default and restructuring during the COVID-19 pandemic, and the recent increase in bonds classified as green under various standards. However, the debt issuance volume of German companies remains significantly below that of their French competitors and is roughly on par with that of companies domiciled in the small country of the Netherlands. The high issuance volume in the Netherlands can be attributed to the large number of German and foreign companies maintaining Dutch group finance subsidiaries. In Germany, this became standard practice in the 1980s when government approval was still required for bond issues. The fact that this practice has continued even after the abolition of these requirements at the end of 1990 suggests the presence of other competitive disadvantages for Germany as a financial center. One of them, alongside German trade tax, is the broad judicial review of bond terms which German courts apply. So in the next 28 minutes, I will explain the legal basis for these reviews, including key uncertainties for market participants, and discuss the possibility of circumventing these reviews through choice of law clauses in bond terms. Finally, with reference to the scope of the EU Unfair Terms Directive, I will outline how Germany's position as a financial center in Europe could be strengthened.
Oh no.
The legal review of bond terms has a long-standing tradition in Germany, dating back to 1900, when the German Civil Code, GCC in short, entered into force. In its original version, the GCC stipulated that the issuance of bearer bonds on the German market required government approval. In the 1950s, this approval requirement was extended to cover order bonds as well. And while the GCC did not explicitly mandate a governmental review of bond terms, the approval of the bond issue as a whole was subject to the discretion of the competent authority. That discretion was guided by the purposes of the approval requirement. On the one hand, preserving the proper functionality of the capital market, particularly through the ability to limit private bond issues. On the other hand, protecting bondholders by preventing unfair bond terms. The latter purpose must not be understood to imply that the competent authority carried out a review of terms in every single case. In practice, no such reviews were conducted for two reasons. First, the territorial scope of the approval requirement was limited to bonds issued in Germany. Perceiving the approval process as an unnecessarily onerous burden, German issuers increasingly favored using Dutch domiciled besloten Vernootschappen to issue bonds. Second, even for the remaining domestic bond issuances, bond terms were actually not scrutinized. The reason for this was the grossly inadequate staffing of the responsible body. Just 2 mid-level civil servants at the Federal Ministry of Finance. Approvals were not granted for individual bond issuances, but ended up being general authorizations covering an indefinite number of issuances over the course of 1 or multiple years. As a result, there was no examination of bond terms at all. Since the abolition of government approval at the end of 1990, German companies enjoy full issuance freedom, meaning they may place bearer and order bonds on the market without prior governmental approval. However, the objective pursuant to the legislature, enhancing the international competitiveness of Germany as a financial center through deregulation, was not achieved. The old approval regime was merely replaced by a different and equally burdensome constraint, the judicial review of bond terms. German courts, including the Federal Court of Justice, have repeatedly, since the beginning of the 1990s, held that bond terms qualify as standard terms under general terms and conditions law. Consequently, they may be reviewed by courts under Section 307 to 309 of the GCC. Unlike the old pre-issuance governmental approval process, judicial review can only be initiated after issuance as part of legal proceedings launched by bondholders. The judicial review of bond terms under the applicable German statutes has resulted in numerous unresolved legal issues. It therefore cannot be ruled out that courts may, contrary to the issuer's legal counsel, consider provisions in the bond terms to be invalid. In such cases, the issuer's performance obligation towards bondholders remains binding, while any resulting gaps in the bond terms are covered by default statutory provisions which tend to be unfavorable to issuers. Consequently, issuers face the risk of unforeseen financial burdens, the extent of which may be existentially threatening in the case of large-scale issuances. I will highlight 3 examples to illustrate the scope of legal uncertainties. Where bond terms are subject to judicial review under German General Terms and Conditions Law, it must be noted that Germany, I think as well as Austria, has implemented the requirements of the EU Unfair Terms Directive not only for consumer contracts, but beyond what was required, also for contracts between businesses. However, the legislator did not set out a uniform standard of review that would apply all clause prohibitions equally. Instead, due to the fundamental legal distinction between consumers and businesses, Section 310 of the GCC excludes certain clause prohibitions where the counterparty is a business. The Federal Court of Justice has interpreted this to mean that these clause prohibitions only apply if the current bondholder of the contested bond is a consumer. The result is a bifurcated standard, and this bifurcated standard raises 2 questions that are considerable relevance for the fungibility of the securities. That is, the interchangeability of individual bonds within an issuance, which is essential for their tradability. The first, initial subscribers in a public issuance are not only businesses. They are a homogeneous group consisting of consumers and businesses. Could the bifurcated standard result in certain provisions being valid vis-à-vis business investors and invalid vis-à-vis consumers? And second, in secondary trading, bonds can be transferred from businesses to consumers and vice versa. Could the bifurcated standard mean that a provision that was previously valid becomes invalid upon acquisition by a consumer and then somehow revives upon resale to a business investor? And all this considering the fact that due to the anonymity of the market, purchasers are typically unaware of who their legal predecessor was.
Yeah.
Most provisions in bond terms do not fall under any specific clause prohibition, but are subject solely to the general clause of Section 307 of the GCC. According to this provision, terms are invalid if they unreasonably disadvantage bondholders contrary to the principles of good faith. The interpretation of these indeterminate legal concepts is guided by the essential principles of the default provision from which the clause in the bond term deviates. In contrast to other types of contracts, such as sales or service contracts, where the GCC offers a detailed set of default provisions, there is no such statutory model for debt securities. The provisions on bearer bonds in the GCC do not contain any default rules regarding the content of the debtor's performance obligations. Rather, they are limited to securities law rules. The German Commercial Code mentions bonds only once in Section 367, dealing only with their acquisition and offering no guidance on the content. Even the German Bond Act does not contain provisions regarding the content of bond terms, except for one rule on collective termination. Instead, the Act merely provides a legal framework for collective amendment of bond terms through bondholder resolutions and the appointment of a joint representative to safeguard their rights. This lack of regulatory guidance burdens courts with the task of deriving the principles for judicial review from unwritten legal norms, resulting in significant legal uncertainty for all parties. In principle, issuers may structure bondholder rights similarly to pecuniary rights of shareholders. In such cases, the judicial review of bond terms must, according to a fundamental decision by the German Federal Court of Justice, be conducted not only under the general clauses of the General Terms and Conditions Law, but also in light of corporate law provisions and principles. This extension of the standard of review continues to be met with skepticism, as corporate law norms and principles are intended to exclusively cover membership rights and thus appear irrelevant as a standard of review for bonds, which, even when structured to resemble equity, do not confer corporate membership rights. Moreover, there remains significant uncertainty as to which features are necessary and sufficient to qualify a bond as equity-like. The definition offered by the Federal Court of Justice, namely that the terms must entail pecuniary rights and obligations corresponding to those associated with share ownership under statutory law, provides little clarity, but rather adds uncertainty regarding the applicable standard of judicial review. The legal uncertainty associated with the judicial review has prompted numerous German issuers to attempt to avoid such reviews, primarily by choosing foreign governing law, most commonly English law. These attempts, however, have been unsuccessful. In principle, issuers of debt securities are free to choose the applicable law and thus to subject the legal relationships embodied in the securities to a foreign legal order. According to well-established case law, of the German higher regional courts, however, this does not apply to the review of bond terms under German general terms and conditions law. Where the securities are publicly offered in Germany, the higher regional court of Frankfurt consistently holds that the issuance as a whole has a close connection to Germany, and as a result, the German general terms and conditions law applies to all individual bonds pursuant to a special conflict of laws rule, regardless of the terms governing law. And even more, accounting to the higher regional court of Frankfurt, even where securities are not publicly offered in Germany, the bond terms remain subject to judicial review under the German general terms and conditions law if German consumers acquire the securities on the secondary market. In such cases, the court has held that the German Ordre public requires the application of the GCC, since English law, namely the Unfair Contract Terms Act of 1977 and the Unfair Terms and Consumer Contracts Regulation of 1999, do not apply to bond terms and thus do not offer investor protection equivalent to the German law. In response to this specific Frankfurt case law, issuers have increasingly included jurisdiction clauses in their bond terms. These clauses stipulate, for example, that all disputes shall be submitted exclusively to the courts of the United Kingdom. According to a recent decision by the Higher Court of Cologne just 3 months ago, such clauses, however, violate Article 19 of the Brussels 1A regulation and are therefore invalid vis-à-vis consumers. As a result, German consumers may bring claims against the issuer at their place of residence under German law. The numerous, albeit unsuccessful, attempts by issuers to circumvent the judicial review of bond terms under German law have drawn the attention of the German legislature. Back in 2003, the Federal Ministry of Justice responded with a discussion draft for the reform of the law on debt securities, aiming to enhance the attractiveness of German law and thereby strengthening Germany's position as a financial center. The draft did not propose abolishing judicial review altogether, but instead, inter alia, the introduction of new sections 795 through 795A of the GCC, comprising 2 innovations aimed at significantly reducing prevailing legal uncertainty. First, the review of bond terms was to be excluded from the scope of general terms and conditions law and governed instead by a newly introduced specific general clause in section 795 of the GCC draft. Although this draft provision contained the same indeterminate legal concepts as section 307 of the GCC, the mere substitution of the legal basis would have eliminated a major source of legal uncertainty, namely the bifurcated standard of review under general terms and conditions. Second, section 795A and D of the GCC draft were intended to introduce statutory provisions addressing certain practically relevant clauses in bond terms, namely the debtor substitution and bondholder termination rights. In this way, at least the basis for a statutory model would have been established, helping to define the contours of the proposed general clause and thereby further enhancing legal certainty. Unfortunately, these proposals were never enacted. The German legislature deliberately postponed the reform, citing 2 reasons. the unresolved applicability of the EU Unfair Terms Directive to bond terms, and the ongoing revision of EU's consumer protective directives, including the Unfair Terms Directive, in which the German government intended to advocate for a clearer scope, especially regarding bond terms. Since the promulgation of the Consumer Rights Directive in 2011, 14 years ago, it has become evident that the reform of EU law has fallen far short of the German legislature's expectations. The Unfair Terms Directive was neither incorporated into the Consumer Rights Directive nor fundamentally revised. In particular, the envisioned clarification of its scope with regard to bond terms never materialized. The German legislature has made no further attempt to reform the judicial review of bond terms since the Consumer Rights Directive entered into force. Accordingly, the question remains whether review of bond terms is required under the EU Unfair Terms Directive, or whether it reflects an overly expansive application of the German law. Pursuant to Article 1 of the EU Unfair Terms Directive, the directive applies to terms and contracts concluded between a seller or supplier and a consumer, which have not been individually negotiated. German courts, however, take a differing view that, especially in the case of debt securities, the relevant relationship is not between the parties that concluded the contract, but is the one between the issuer and the current bondholder. The rationale behind this view is that consumers have no influence over the bond terms, regardless whether they purchased the debt securities at issuance or on the secondary market. According to this interpretation, bond terms fall under the scope of the EU Unfair Terms Directive, meaning that German law may only dispense with the unfairness review under Article 3 if the directive itself provides a sector-specific exemption with respect to bond terms. However, securities are mentioned in the directive only once, in the number 2 of the annex. This provision stipulates that certain specific clause prohibitions, so the subparagraph G, J, and L, do not apply to securities transactions if the price depends on capital market fluctuations that are beyond the trader's control. From this very narrow exception, it follows that the EU Unfair Terms Directive applies to all other securities transactions, including the bond terms structuring the long-term relationships embodied in debt securities. The fact that the EU Unfair Terms Directive, at least according to German courts, applies to the debt securities and requires a review of bond terms means that the German legislature cannot exclude such review entirely. To find alternatives that reduce legal uncertainty and make German law more attractive, it is worth looking at the legal framework of the world's leading capital market, so New York City. US courts do not review the content of bond terms at all. This judicial restraint is not just a matter of broad party autonomy. Rather, it primarily results from the fact that in the US, a jurisdiction known for its liberal legal environment, investor protection is ensured by the Trust Indenture Act. The Act sets mandatory standards for bond terms and requires the SEC to verify compliance before bonds are issued. Such a division of responsibilities could be adopted in European law without lowering the current level of investor protection. I will limit myself to outlining the to the two key elements of this proposal. Enhancing legal uncertainty would require that the review of bond terms takes place prior to the issuance of debt securities. Since securities may only be issued following the prior publication of a prospectus approved by the competent authority, one viable approach would be to integrate the review into the existing approval procedure under the prospectus regulation. Currently, the authority's review is limited to assessing the completeness, the comprehensibility, and the consistency of the submitted draft prospectus. For debt securities, the scope of review could be expanded to cover bond terms as well. Since such a review is, depending on the complexity of the terms, may involve difficult legal questions and delay the approval process, it would be advisable to make it optional, available upon request by the issuer only. Under the current legal terms and the current general terms and conditions law, regulatory approval of contractual terms does not preclude subsequent judicial review. Accordingly, the proposed expansion of the prospectus approval procedure would only create the intended legal certainty, so-called safe harbor, if courts were prohibited from re-examining the approved bond terms. In such a scenario, investors would need the ability to distinguish between debt securities that have undergone such review and those whose terms remain subject to potential judicial scrutiny. To that end, the prospectus could contain a clear statement specifying the nature and scope of the review conducted. Two foreseeable objections to the proposed optional expansion of the prospectus approval procedure come to mind apparently. First, is regulatory review compatible with the EU Unfair Terms Directive? And second, would this take us back to the approval requirements I mentioned at the beginning of my presentation before the end of 1990? Neither concern presents a genuine challenge to this approach. The EU Unfair Terms Directive in Article 7 merely requires that appropriate and effective means be available in member states to stop the use of unfair terms, but it does not prescribe any specific procedural mechanisms. In particular, the directive does not require that review be entrusted to the courts. Accordingly, the review of bond terms may also take place within a preemptive administrative approval procedure. The proposed expansion of the prospectus approval procedure harkens back to the former approval requirements that were abolished at the end of 1990. But it differs from that earlier regime in several key respects. Most important, it would not reintroduce a prohibition on issuance. Under the former legal regime, issuers were not allowed to place bonds on the domestic market without any prior approval. Securities issued in breach of this requirement were considered void. In contrast, under the proposed system, issuers would be free to respond to the authorities' concerns by narrowing the scope of their request for review, but importantly, could still proceed with the offering, accepting the risk of subsequent judicial scrutiny. So the current state of affairs and the significant legal uncertainty it entails regarding the issuance of bonds does not harmonize with the German desire to be a strong financial center. In my opinion, the proposal to integrate the review of bond terms into the pre-issuance prospectus approval procedure would significantly reduce legal uncertainties and could be a building block of a stronger EU capital markets union. With this outlook, I will conclude my presentation, and I look forward to hearing you on the thoughts that you can find on the handout that was circulated by Mayor. Thank you.
No, thank you, Timo. Thank you for outlining this, as embarrassing as it is, I feel, for the German legal order. Yeah, but I mean, it's a common theme amongst Germans to be a bit self-deprecative in this respect. So anyway, let's open the discussion. Are there any questions to Timo at this point? Yes, Noreen. Oh, Mr. Vermeulen. Did I get your name right? Vermeulen.
It was fine. Thank you very much. I really enjoyed it. It was indeed quite surprising, the picture of the legal landscape that you painted. Even the dog agreed. This is not ideal. But my question was, are there other EU countries where the courts are similarly protective in the sense that they say the unfair terms directive applies and you can't contract out of it?
Yeah, I think there's a similar judicial review in Austria going on. Because it's the same problem with the unfair terms directive. So not only Germany, but Austria as well, they both adopted this kind of directive, not only for consumer contracts, but for business-to-business contracts as well. So, but this does not change the thematic focus. It just creates another problem, but it doesn't expand the thematic focus or scope. So the basic question remains, and I think I hope for the European Court to have an opportunity to decide on that, is just whether bond terms are within the scope of the directive or not. So, because if you read the English version of the directive, you could say it just applies to.
I don't know where you have to find that. To find that somewhere to the censor.
So the English version, the wording is very clear. Yeah, that's right. Thank you. The English version is pretty clear because it says contracts concluded between. So it points to the aspects of the conclusion of the contract. And if you just look for all the big issuance of bonds, there is no consumer in there. So the consumer is not party to these contracts, but it's just done between usually a bank and the issuer. And afterwards, this kind of bonds are distributed on the market. So, but with all, you get some problems when you look to the small issuance procedures. Because to the small, the direct issuance procedures, you can have consumers in that as well. So, and that's why the German court says, and I think it's a fair argument, as someone who purchases a bond on the secondary market, you are not able to distinguish on the way the issuance process was done. So you have the basic, every time you take a closer look at that, it comes down to the problem that is a huge anonymity on the market. You do not know who your predecessor was. You do not necessarily know how the issuance was done. So that's why you could always say there could have been a consumer in the process of concluding these contracts. And that's why they say, if it's possible, it applies.
Yeah,
so that's their reasoning.
It seems that the two logics are somewhat irreconcilable because it's the very point of a capital market to, you know, to gloss over
exactly.
the chain of holding preceding your acquisition. But I don't want to get involved, although I would love to. Nareen, you. Oh, please, you go.
I'll be quick. Thank you very much. I found it really fascinating. In the context of reform perspectives,
yes,
I do wonder whether we might want to think about the changes in also loan markets and the liquidity that we have in the syndicated loan markets nowadays, and how many of these issuers might potentially address problems that the bond issuance creates by loans are tradable now. Yes, they're not securities, the way I understand they're not securities, but we can address that. We see nowadays very huge syndicated loan deals of billions and billions, and you can have for investment grade wars, you can have all these complex loans that are everywhere in the market. And there is no uncertainty there because it's loan market association documentation. It reduces uncertainty, it reduces transaction costs. So I wonder if there's some empirical data showing increase in syndicated loans in Germany over, the past years or so. It is a way to, bypass this problem if you are both investment rates issuer and non-investment rate, because, there is convergence in one market.
Yeah.
Both for investment grade and non-investment grade.
Yes.
I'm not saying bonds are not important, they are, but I'm wondering if this should be taken into account in the context of reform, that there is a similar type of situation now in the loan markets, and you don't have to be investment grade anymore to.
Yeah.
Thank you so much. Sorry.
Thank you. Do you want to respond right away, or do we?
Yeah, so from a German perspective, you would completely separate these two issues. You would say one is the loan market and it's something completely different. And from a German perspective, it says for everything that is a loan, we have a detailed set of default rules, not just applying for consumers and businesses, but for business transactions, pure business transactions as well. So there is no such huge amount of legal uncertainty. Some uncertainties there are still, but not such a huge amount. With the securities market, we have a complete different thing. That our problem with that is just like if the German High Court, I do not think they would change it. So although it is a huge disadvantage on the international market, so the German government says we're not going to interfere because we are afraid of doing something that is not valid under the EU Unfair Terms Directive. So you could just pray for some revision of the EU Unfair Terms Directive, or you could just say, okay, we need to kind of integrate that in another way in the market. And to that point, I find it very interesting what is going to be, what takes place in the US. Because usually the US, you say, okay, there is private autonomy and you can just do whatever you want, if you agree on that. And there are the bonds and you can buy them and you cannot buy them. But the interesting thing is just the US has statutory rules that you have to adhere to issue your bond on the market. And the US says, okay, we want that because we want the investors not to focus on the bond terms and not to include some legal uncertainty on that. We just want them to purely identify the bonds they want to purchase and to invest on only by the economic factors. That's why they go to the statutory model.
Yes, please.
My question is a bit technical, I think, but the interaction between this legal uncertainty that you're introducing here and credit ratings, and then also on settlement finality as well. Could you say a little bit about those?
Yeah, the interesting thing about credit rating is it's very interesting because the credit rating agencies, they know this kind of legal uncertainty in the German market, if the German law applies. And they usually ask for scholars to give some advice on the legal uncertainties, on all the points that they say there is no high court ruling, for example, on that. So they try to include it. I do not know how they measure it exactly. But you usually could say if the single bond of an issuance has a nominal value of 1,000 euros, the probability that a consumer or retail investor would buy it is pretty high. So it's just like the question remains, is it worth going to court for them? So, and the problem usually is if one goes to court and he has just like 2 single bonds, everyone else will follow. So if he wins, sure. So it's just kind of spreading because you are obliged to apply the same rules to every bondholder. And that's why they want to treat everyone equally.
If I can pick up on that, so particularly in the area of consumer protection law, we have these consumer protection organizations that pick up certain clauses, you know, without there actually being anybody harmed, but on a more sort of prophylactic kind of notice. Do we see that in this area? No,
absolutely no, because they just focus on the very small problems. They usually go to banks and just say for just to kind of have a small payment for your bank account every month, just like €1 or €2.
So they focus on different topics.
When no consumer ever would sue for that. So here you see some bondholders usually suing for that. The interesting thing with that is not everyone who is suing is a consumer as a bondholder. So sometimes there are businesses they sue. So it's like the professional investor who's suing. But they say if this kind of bifurcated standard, if one clause is invalid to consumers, it has to be invalid to us as well, because otherwise these kind of bonds are not tradability anymore.
I was going to ask you whether a practical way around this was just to always issue high denomination bonds.
Yeah.
And then professional investors.
So it comes down to the basic thing with the bifurcated standard is just a problem that comes from the book. And in practice, you need to apply a uniform standard. But the problem with that is you cannot lower the standard for the consumers. So you have to raise the standard. So you have to raise the standard for all the businesses.
Yeah. If there's no further question, I have one. Isn't the problem, because sometimes when we quote the Dodd-Frank Act, okay, we tend to leave out the complete title. Dodd-Frank Wall Street Reform and Consumer Protection Act. So not wanting to, shift the blame, but is it possible that the entire inclusion of consumer protection logic into investment and bond law is the actual heart of the matter? Because I mean, we have been, especially here in Austria, we've been seeing people experimenting with the international jurisdiction side of this. So for example, during the diesel scandal, they were trying to wear the hat of a consumer in order to make Austrian courts competent to these cases, thereby also equating investor with consumer. Wouldn't that be at least a great reduction of the problem if we got the consumer protection just by principle out of the equation?
For sure, but you need the change or the clarification on the scope of the EU Anti-Trust Directive. That's what you need.
It's the consumer concept is the problem.
If you just say, okay, capital markets are outside of the consumer market, it's something completely different, and you separate them, then the problem is solved immediately.
I see.
The interesting thing is how this comes in.
And then this is perfect. This is a perfect example of a sort of German legal thinking. It's a very text-based, very logical. Or sometimes when we say that legal certainty is at stake, we really mean we're being driven out of the comfort zone of statutory interpretation. That's what Germans typically mean, because I really don't, especially with so many common lawyers present, I don't buy a second into the proposition that statutory provisions were a iota more legally certain than, say, a standing case law on a topic, for example, applying this test.
It's quite interesting, because if you go back to the UK, about approximately 100 years, there has been a lot of litigation on bond terms in the UK as well. But since then, there is a standard, and it's like a kind of statutory guideline deriving from the decisions. And it's a very long-standing standard, that it is pretty clear what is valid and what is invalid. And so we are just lacking this kind of standard. That's why we are just looking to the statutes,
Yeah,
and
yeah.
trying to achieve this kind of same guidelines for
this is-
drafting the
This
terms.
is so interesting on a methodological level, but I think we have to cut it here. Thank you again, Timo, for this marvelous